Admissible or not, why that letter from your pastor may be useless in court. One of the most common frustrations in Utah divorce cases goes like this. You have a letter, an email, a report, something that feels decisive, and the court refuses to admit it. From your perspective, that feels ridiculous. It's relevant, it's written down, it comes from someone credible. Why can't the judge just read it? Here's the answer. Courts don't decide cases based on information. They decide cases based on admissible evidence. And in contested hearings and trials, evidence usually comes in through live witnesses, not paperwork. A document does not testify, a person does. A document is just an exhibit, and exhibits have to be introduced through testimony. Without a witness, a letter is just paper. Under Utah Rule of Evidence 801, hearsay is an out-of-court statement offered to prove the truth of what it says. Rule 802 makes hearsay inadmissible unless a specific exception applies. Letters, emails, therapist notes, declarations, most of them are hearsay. And the deeper issue isn't technical, it's fairness. When you submit a letter instead of calling the author to testify, the other side loses the right to cross-examine that person. Cross-examination isn't a loophole, it's how courts test credibility. A judge can't ask follow-up questions of a letter. The opposing party can't probe bias, exaggeration, faulty memory, or missing context. That's why foundation matters. Under Rule 602, a witness must have personal knowledge. Under Rule 901, evidence must be authenticated. A live witness can do that. A standalone document usually can't. And here's something people underestimate. Documents are easy to manipulate. Signatures can be copied. Letterhead can be recreated. Emails can be forwarded, truncated, or stripped of context. Screenshots can omit metadata. Even without bad faith, context disappears. Authentication exists because courts require verification, not assumptions. Now, people often say, but it's sworn. An affidavit still isn't live testimony. In contested trials, a sworn statement is usually still an out-of-court statement. Unless a rule specifically allows written testimony or the parties stipulate, you need the witness in court. Others say, but it's a school record or it's a business record. Maybe, but those terms have precise legal definitions. To qualify under Rule 803, subparagraph 6, you usually need a custodian of records or a proper certification under Rule 902, subparagraph 11. And even then, embedded statements can still be hearsay. Filing something with the court, even a GAL report, does not automatically make every statement in it admissible for its truth. Procedure still governs. Here's the key distinction people miss. Admissibility and weight are not the same thing. Admissibility asks whether the court is allowed to consider the evidence at all. Weight asks how persuasive it is. A letter can feel overwhelmingly convincing in real life and still be completely inadmissible in court. If it doesn't get through the evidentiary gate, the judge never even weighs it. So if your case depends on what someone observed, concluded, or believes, plan for that person to testify. If they can't or won't testify, you probably don't have admissible proof. That's not the court being difficult. That's the system enforcing fairness. Evidence lives in witnesses, not in paperwork. Once you understand that, you stop building cases around documents and you start building them around proof.